My name is Lara Schwartz. I'm a lawyer and a professor who teaches law and government here at American University, and I'm happy to be introducing you to this moot court exercise. Moot court is an opportunity that very few school scholars get to be involved in. In fact, it's often a law school exercise, a way of training lawyers not only to think like lawyers, but to act as lawyers, practice to be lawyers in the future. But moot court isn't only for lawyers, it isn't only for law students. It's an excellent exercise for any student looking to find their voice, learn to make an argument, to engage with the rules of the system we live in, talk about justice, talk about fairness, and that's why Higher Achievement has Moot Court this summer and why these scholars and you are going to be working on it. So what is Moot Court, though? Moot Court simulates the courts of appeal, which are the courts that answer legal issues and legal questions in our legal system. Now, a lot of people are familiar with trial courts, and in fact, at Higher Achievement, sixth grade scholars do mock trials. And mock trial, or a regular trial, is there to find facts. Trial courts will answer questions like, did Alex rob a bank? Did that big chemical company dump pollutants into the river? And lawyers, in these cases, will present evidence, an eyewitness statement, some fingerprints, a water sample from the river in the case of the pollution. And a judge or jury will look at all of this evidence, will weigh it and say, okay, what happened? Well, that's not what courts of appeal do. Courts of appeal answer questions of law. So in the case of our bank robbery, it wouldn't be, did Alex rob the bank, but did the police behave illegally when they arrested him? Did they coerce him into an illegal confession? Did they search his house when they shouldn't have? These are legal questions. We all read about these kinds of legal cases in social studies. We don't use the word court of appeal or moot court very often, but for example, you and your scholars might have talked in the past about Brown v. Board of Education, where the Supreme Court ruled that segregated schools violate our Constitution. They discriminate, violate our Constitution. And that's the kind of question that the students will be answering in our moot court. They'll be looking at a case about sex discrimination in middle schools and acting like lawyers.
Hi, my name is Asha Smith, and I am a senior at American University, Moot Court student, and also mentor at the Ward 1 Center. I'm here to talk a little bit about what Moot Court will look like for the scholars. So first, we will be learning about our case record, which has to do with the school dress code, and students will be advocating to challenge the school dress code, and they will be doing so in the form of an opening statement. They will be wrestling with tough legal questions in front of a judge. So some of these legal questions could look like, why is the dress code discriminatory? Is it based on stereotypes of ideas of boys and girls, or is it actually based and serve a real purpose for real differences between the two genders? If that is the case, the court is more likely to rule in favor of them, but if it is based on stereotypes, the court is more likely to rule in favor of the students. So the scholars will be working over the summer to develop opening statements. They will be working with their teachers and other students to develop the elements of these statements. So some of the things that will go into this are precedent. Precedent is established case law where courts have established a rule. These rules apply to future cases, and that is what students will be referring to when building their opening statements. They will also come up with a creative narrative that goes in their opening statement to convince the judges of their point. Students will work hard to build their opening statements with the help of their teachers and their peers in order to argue like a law student or an appellate attorney. However, the case record has been tailored for scholars' age, and we will be focusing on answering questions, tough legal questions that they will have to face when presenting their oral arguments to judges. So some of these questions might include, why does this dress code matter? Or where do you draw the line on the appropriateness of the dress code? Further, Professor Schwartz and I will go on to talk about my experience as a moot court scholar and what it looks like and what it practically looks like.
I'm here to show you how you can set up your moot court room. So oftentimes you'll have the two advocates sitting at different tables with a space in between, or they'll be sitting at one table next to each other. Behind the two advocates is where you'll have scholars who are not doing their arguments. And then over here, you'll have a podium where the advocates will put their speeches or their outlines on to give their presentation. And then facing the speaking or the scholar giving their presentation are the judges, so that they're looking at each other. And then you have the scholars not giving their presentation sitting behind them, so that the advocate speaking does not have to look at their other scholars. So the first thing that we would do for this presentation is you'll have the judge call up the first advocate speaking. So
counsel for the appellant, please approach. Counselor, you may begin.
May it please the court. My name is Astonique Robinson, and I represent BN, DM, and CJ. Today, this court must decide whether Arkansas school districts have the right to enforce unjust student dress codes, alienate students, and engage in gender discriminatory practices. The question that the court will answer today is whether Little Rock School District has violated the Equal Protection Clause of the 14th Amendment by establishing an overbearing and discriminatory dress code policy. We strongly believe that the Little Rock School District has violated the 14th Amendment rights of students by creating and enforcing such a policy. The 14th Amendment provides equal protection under the law, and we have seen that in the Little Rock School District, that equal protection is being denied. We are aware that in school environments, a student's rights can be circumscribed, but there is a difference between circumscribing rights and denying rights. In this case, students are being targeted for dress code violations based solely on gender. Male students have been reprimanded on numerous occasions for wearing hooded sweaters, while their female counterparts just skate by. Likewise, there have been numerous accounts of male students wearing shorts that violate the dress code, but there has been no intervention by the administration. Little Rock School District contests that these policies are enforced fairly regardless of gender, but the evidence in this case suggests otherwise. The punishment for dress code violations is severe and has the power to impact the future of students who are reprimanded. Colleges, employers, and other future opportunities will be made aware of these infractions. If this code is not being enforced fairly, then it should not be enforced at all. In many ways, this policy places an undue burden on the students and their families. In the case of DM and BN, the financial burden is significant. In order to comply with the school dress code, these families must go out and purchase an entirely new wardrobe. In the case of CJ, the burden becomes more significant. CJ, unlike other students, is being denied the right to identify and express their gender or lack of gender the way that they see fit. It is not the place of the Little Rock School District to identify CJ's gender and mandate a dress code based on their assumptions. Even when CJ is following all clauses of the dress code policy, they are still reprimanded. The reason CJ is being reprimanded is for gender expression, nothing else. The Supreme Court decided in the 2013 case US v. Windsor that it is unconstitutional to deprive people of liberty by making them second-class citizens. This interferes with the equal dignity of all citizens. By forcing CJ to conform to the societal view of what gender should be, the school district makes them a second-class citizen and denies them liberties that other students have. Little Rock School District claims that these policies are put in place to combat numerous social issues, but in many ways this policy perpetuates and even heightens the same issues that they aim to solve. They claim that this will diminish sexualization and consequently decrease eating disorders and other health issues. By forcing students to cover parts of their bodies, it sends a message that their bodies are the issue. We have seen that as a result of this policy, students have been made to feel uncomfortable in the classroom environment and that they have been bullied. Students have been called crude things like stupid queer and have been alienated for their body types. The school environment has become more hostile than ever, and this code takes away from the students' ability to learn. The court is free to strike down legislation that interferes with liberty unless the government can demonstrate that they are seeking to achieve an end that is not arbitrary, capricious, or unreasonable. There is no evidence that these issues are prevalent in this school district. There is also no evidence that this dress code policy has made the school environment safer, more accepting, or that it has made students less susceptible to sexualization and gang involvement. When a policy incites bullying, creates unnecessary financial and social burdens, and so serves no purpose for the school district or the students, we must draw the line.
Counselor, you mentioned this case involves gender-based discrimination, but to me this seems like normal standards between boys and girls. Aren't there real differences between boys and girls, and can't we have different requirements based on that?
Judge, if we're talking specifically about the anatomy of boys and girls, then yes, there are differences. But if we're talking about gender and gender expression, then it's difficult for us to draw a line and say or mandate to students that they are male or female, they're a girl or boy, and tell them this is the way that you must dress as a result of what we see that you are. It takes away from the students' right to identify. It takes away from their form of their self-expression, and it alienates them in a school environment.
So, you mentioned liberty and freedom. Yeah, liberty to express yourself, dress the way you want. This is important, but liberty in middle school, it isn't the same as out in the world. The students can't wear bikinis. So, where would you draw the line here? Would you prevent the Little Rock School District from, let's say, banning bikinis? Or is that too much too?
Judge, I'd say that clothing that actually has been proven to incite issues or distract from the learning process of students would be under the jurisdiction of the Little Rock School District to actually, create a policy that combats that. So in that case, bikinis would obviously take away from the educational value of attending school, and that would actually be something that would incite an issue. But in this case, we're saying that shirts that may show the collarbone or hoodies that have not been proven to cause any problems in the school environment should be banned.
But it's complicated. It seems to me because in some communities, a collarbone wouldn't be distracting or inciting, and in some it very much would be. That seems like a community standard. Different degrees of modesty, different families, even. Why can't we let the school decide what is distracting? I mean, these are professionals, principals, people who know all about kids.
I think that it's important for the Little Rock School District to act on precedent. And so, as of right now, there's no indication that students in the school wearing hoodies actually have gang affiliation. Now, that would change the case completely. And if they were to have gang affiliation and that was creating issues, whether in the community or in the school, then it would be appropriate for Little Rock school districts to say we're banning hoodies and here's why. Here's a reason that we're giving. But in this case, they're going based on other trends that are happening in the U.S. and not necessarily things that are affecting this specific community.
Okay, in Olson v. Board of Education, the court ruled that a school could prohibit boys from wearing earrings because it was a sign of gang violence. What makes the Little Rock School District case different, and why can't they ban hoodies if this other court was able to ban boys from wearing earrings?
I'd say that in the Olson v. Board of Education case, there was an actual threat. There was a threat of danger, and if there are students involved in gangs in the school and they're being connected in the school through this symbol of earrings, then that poses a threat not only for the community but for the students of the school as well. And it also can become a tactic for recruitment. What we see in the Little Rock case is that students are just wearing hoodies because they're wearing hoodies. There's no affiliation to outside criminal activity or gang affiliation. And so there's no reason for their right to wear a hoodie to be restricted based off of assumptions of what could happen in the future.
So would you say that the potentiality of a threat is where you draw the line?
I'd say that if we have clear evidence that there is a connection between clothing and some illegal activity and that could severely affect the community or the school, then we'd have to draw the line and create a restriction there.
So, Counselor, I'm glad you brought that up because I'm inclined to agree with you about this question of the hoodies. You're right, the record doesn't have evidence, for instance, about gangs. This makes a lot of sense what you say. The Little Rock School District did say that sexual harassment is on the rise. They presented all of this evidence, across our country, bullying, harassment, so-called sexualization of girls, where they're treated like sex objects, and they wanted to do something about this. So, is that not enough? Knowing that across this country, middle school girls are being subjected to this so-called sexualizing. What more does Little Rock need to be able to take action?
I'd say in this specific case, it's difficult for us to say women are being sexualized, let's have them change a dress code to cover up their bodies. That sends the wrong message to the students. First, to the people who are being targeted, that it's their fault that their bodies are uncovered, and that's the reason that they're being targeted. And it sends a message to the entire school community that once their bodies are covered up, the issue is gone. And unfortunately, that's not the case. I think what Little Rock School District needs to do is take this on a case-by-case basis and look at specific students who are being targeted and focus not so much necessarily on the victims in this case, but on the perpetrators and how they can educate or how they can institute programs that are going to help those students and prevent that behavior in the future.
Thank you.
The goal of our teacher's guide, which you are going to receive, is so that you can be prepared, so when your scholars have questions, you know how you can answer, and so you know how to set up a moot court and just move through the process slowly. So with our teacher's guide at the beginning, we have a list of goals of what we are saying that we would like our curriculum to accomplish, in particular based on our lesson plans and the outlines. Reading through that will help you understand better what the goal of this project is and how you can help implement it better for your students so they understand. Our content is very flexible, but there's lots of pieces in there that can help you understand better what you are teaching your students. One is we have an introduction to what appellate court is. This is important because this is the type of court setting that the students will be working in order for the scholars to truly understand and implement the moot court process perfectly, you need to understand what the appellate court is. Then we have a learning outcomes and goals for the program. So I'll show in there what the learning outcome and goals for moot court is. Then we have a piece on what mock trial is versus moot court. A lot of students have completed mock trial earlier in school and probably in higher achievement. So there's a little bit of discrepancy between the two. It can get confusing, so helping the students understand what that is can help them clearly define what their moot court experience is going to be like. Next, we have a description of why appellate courts are important and what kind of cases are heard there. We have some casework and case studies that are available in the teacher's guide and in the scholars packet so they can see what appellate court cases look like. Next, we have a background on constitutional law, why constitutional law is important, and how it ties into the appellate court and the cases that they'll be working on themselves. And then we have a glossary at the end. This glossary is going to help you understand the terms. That way you can also define terms for the students if they ask. Being prepared to use legal jargon is very important in this, and hopefully this will help you out a lot so you can implement your moot court in class.
What is your best advice for scholars preparing for their oral argument?
I'd say the best advice I could give is having a clearly structured outline for them, because going into this, it's difficult to know, exactly what an oral argument really is and what it should entail. So if you give them specific blocks of information of what should be there, so starting out with introducing themselves, explaining who they're representing, and then going from there to explain kind of what they're arguing, framing their argument, and using case law, I think that gives them just a sense of comfort in what they're doing so that they know they're actually following some steps and they're not just going on a whim and writing an argument.
Definitely. And how can scholars best prepare for the questioning section?
I think I found that in my experience, the best thing to do is to work with someone who's arguing the exact opposite of what you're arguing. Usually because their best points are your worst points, and by hearing what they have to say and what they plan to present, it helps you to be one step ahead and have answers to those questions and find the holes in your argument. So it can really just be constructive for you both to sit together, find those holes, and then separately obviously go work and figure out how to patch that up. And then I think also having someone else hear your argument or hear you speak, they can tell you what sounds weird, because all the time we don't know necessarily how we're sounding. Tell you what sounds weird, tell you when you're going too fast or too slow, work with you on cadence and things like that.
Great, thank you.
So Professor Schwartz, this is a law school exercise. Can you speak to what kind of skills middle school students will learn from doing moot court?
Absolutely. This is an exercise, I started teaching moot court at the undergraduate level when I came here to AU, and what I found was this is an exercise that you don't need to be a lawyer, you don't need to want to be a lawyer, you don't need to be a law student for this to be valuable to you. It brings out the best in every student. What I see when I take students through the moot court process, first of all, is that they might be actually terrified to try it. So I think it's important for teachers to understand that if they have a scholar who says, you want me to argue in front of 3 adults and defend myself in front of 3 adults, that you can say to them, yes, you can. Everybody does a great job. But what I find is, even if people are afraid about it, people really find their voice in doing moot court. They learn over the course of engaging with a tough question and answering it and thinking of the really tough challenges and critiques of their argument, that they become more confident in themselves and they become more confident in their voice. And then the action of actually doing the oral argument, where you make your statement and then defend yourself, 3 people asking you rapid fire questions, enables a person to really understand how good she is, how much do I know as a student and an advocate. You don't really get to do that when you write a paper and your teacher might say, great job, nice essay, but you might not even believe it, and you get that opportunity to believe it when you're doing an oral argument. So it's that confidence builder. Now, higher achievement scholars are learning to become self-advocates. They're learning to become ambassadors for themselves, for the programs. 8th graders are getting ready to apply to high-achieving, excellent high schools. And one thing that moot court does is enables a person to hold their own in that environment where they're saying, you should believe me and trust me. I've made that preparation. I'm representing myself. I can have this conversation with you as an adult. It's great preparation for instance, an interview, to write a personal essay. And then as well, and this is one reason again that I use it with college students, it reinforces some of those English language art school skills that scholars are working on, utilizing some rule and applying it. Reading a complex text or case record is a good long story for them to engage with. It's a fictional story, but it could be real. Writing a persuasive argument that utilizes evidence to back it up. These are all the kinds of skills that we do in academics. A difference is that you get to really stand up and strut your stuff. And finally, and I feel like in a lot of ways this is one of the most important, it enables them to have a conversation about something that matters to them, such as their rights in school, but in a context in the way that the adults around them or the system around them, in our case the legal system, really would deal with that issue. Not just, do I like my dress code, is it fair, but how would the rules that apply to our world relate to that issue that's very real to them. So 8th grade scholars have so many things going on. As a teacher, I'm ready to admit to myself that maybe school and social studies aren't the central thing in their life. Usually life with their peers is very central to them. They've got a lot of priorities. So you've been a mentor, a great mentor. How does one make this idea of this legal exercise, relevant to them? How does this occupy kind of their real world that they care about?
Sure. So something that higher achievement values is voice. In fact, it's one of the social justice principles. And I think that Moot Court is an activity that speaks to that principle. In my mentoring experience, something I've seen over the last 3 years is that all 3 of those classes had strong voices, and there are individuals who really were searching for a way to adequately make their voice heard. And I think Moot Court is a really important instrument that can do that. And I think that this idea of getting up in front of people you don't know and advocating for an issue that you care about, an issue that you have researched, that you have spent time learning about, is a skill that many people don't have. And it's one that is incredibly important in this world, especially as we go out and we have these aspirations of changing it. Scholars have all kinds of opportunities within the higher achievement context to do this. And I really believe that Moot Court is that tool that will allow them to better formulate their arguments, to find out what's most important, find out what is important to the people they're speaking to, and figure out how to use that to further their cause. And I think that something I've learned in my experience doing Moot Court as well here on the college level is that advocating for issues in a school is so important, and being a student and being able to say, I have a voice, here's what I see, and here's how I think it can be changed within the context of these rules, that is great. And I know that it was challenging for me. I remember I came in as a freshman even, and I was doing the court, and I didn't know what to say. I didn't know how I would be received. I was certainly afraid, but I knew that after I had done it, I had done something important. And that's what allowed me to have more confidence doing it again my senior year, and really saying, wow, okay, I care about education. I care about teachers' rights. I care about students' rights. I care about all these things that happen in a school because this is my world, and scholars can relate to that. This is their world. They go to school every day. Why shouldn't they have an opportunity to present their case, their voice, and have the right tools to do so?
So, Summer Academy teachers, this is a really ambitious assignment, and you were my student doing Moot Court in college, and so I know, even for highly accomplished college students, this is one of the more ambitious assignments. I do think it's very doable. Looking at, a Summer Academy teacher with their brand new crop of scholars, what would you say to them as far as helping make that connection to that scholar, saying, what's the one thing, maybe you don't think you're into social studies or you don't think of yourself as a public speaker, the one thing that a teacher could say to her scholar to get them, motivated, ready, focused on like the big priority, the big values behind what this exercise is?
Sure. So the good news is we have an extensive case record that actually deals with multiple issues. There's not just one issue, there's not just one thing scholars are focusing on. So I would say tell that scholar to find something in that case record that resonates with them. If you can find that one thing that they care about the most, that maybe they have an experience of, maybe they've seen happen to a friend, tell them, talk about that. Put that in your opening statement. Give a story. People love stories. Stories are important. And talk about that within the rules that you are given. So using that set of tools and combining it with something that resonates personally, that's all it's about. And I think that scholars would really take something away from that. We see this in ELA. Something I've seen is that students love to free write. Students love thinking of their own ideas, thinking of their own experiences, and applying that to the school context. So telling that scholar, find that one thing, and it's going to be fine, I think will really boost their confidence and make them feel that they can do it.
And it sounds like, making those connections or finding that one relevant thing, that could be actually a great time if a student is wanting to connect to the real world, for the teachers to draw upon that research packet of information we have about dress code policies in America and sexual harassment and gang violence and things like that in schools, that they could offer to a scholar to say, hey, if this is where you're going with this, you can read this article and maybe build it around that. Would you recommend?
Exactly. I mean, I would say it could even go one step further. Students are all over social media all the time. They see these stories, they see these articles circulating of things going on in the news, they see what their friends are talking about happening in their schools. So they are keenly aware of their world. So there is ample amounts of stories and articles and substance for them to include into this activity. That will not be an issue.
And that's a great thing about being an 8th grade scholar and not a law student, because you really can draw on that creativity and that whole world of information that you want to share. Because good news for the scholars, they don't have to pass the bar
right
at the end of the summer.
Exactly. So, I mean, I'm curious, even in your experience as being on all sides of Moot Court, a judge, a teacher, I'm sure someone who has advocated themselves in Moot Court. Can you talk about something that judges will be looking to hear? What is something that they are looking for out of an opening statement, out of an oral argument?
Yeah, there are a couple of major ingredients, and this is what I would tell teachers to really help their scholars to bring out, and they are these. First of all, we call it a theory of the case, and the lesson plans do describe the theory of the case, but it's basically the one reason you win. A sentence, they'll know it as a thesis statement from their essays. The one reason you win. Your Honors, may it please the court, my name is Lara Schwartz. My client should win because schools shouldn't be allowed to suppress students' expression in this way. So a theory of the case, one thing that if you persuade your judge of, you win, is one. Another thing, and I think scholars will enjoy this component, is so-called framing, basically a statement of what's significant. Paint a picture of a world where you win or where you lose. Make the judges feel like a world in which you lose is a bad world. Wait a minute, am I as a judge going to give schools so much power to limit their students' rights? Or am I as a judge going to take away schools' right to protect kids from very sexualized atmospheres, harassment, gang symbols? So I think being able to say to the judge something about why it matters. You should rule for me. You should rule for the students, because to do otherwise creates schools we don't like. So make it very clear to the judge, why are we here? What's at stake? And the final thing is you. It's yourself. The advocates who I see who can have a conversation with the judges, a real conversation, where they know that they've learned their stuff, they know that they've thought deeply about it, that they believe it, that they care about it, and can have this conversation person to person with these judges in a respectful, professional way, just like they might for their high school interview that they might be doing, or as a higher achievement ambassador. The person who can have that conversation and say, yes, Your Honor, I have thought about this hypothetical you came up with, and here's how we'd solve that. As a professional, as someone who thinks deeply, you do those three things. Come up with a good reason you win. Come up with a picture of the world that the judges, your world, your winning world. That's the world that they want to create, the kind of school system they want. And then be that person that can engage and advocate because you know your stuff, A, and because you're that sort of professional, thoughtful person. And that's it. That's the game. And I think as well, one of the best things too, the fourth thing, is when people seem to be having fun with it, you can really feel the chemistry with the judges and just the quality improving, which is why I would tell teachers to really just keep reinforcing for the students, this is an opportunity for you to shine and explore and make your voice heard. And hopefully that will connect them with how much fun this can be.
Absolutely will.
Thank you for watching, and thanks for being involved with Higher Achievement Moot Court. If you'd like to know more about the program, something you don't see on the website, please feel free to reach out to me, Professor Lara Schwartz, at my email, lschwart@american.edu.